about the conventions which guide the Governor-General, and I think from your excellent essay, which people can find if they go to the link on the ACM site, your Sydney University research essay, you point to how some of the conventions have evolved. You referred to Disraeli, for example. But I was surprised to read recently in The Australian the argument that these conventions, the exercise of these conventions, can be reviewed by the court. And I thought, well, does that mean that Gough Whitlam in 1975, after he was dismissed, could have rushed off to the High Court? I suppose Sir Garfield would have recused himself, but the High Court would have then said, no, no, Governor-General, you've made a mistake here. We think this is what you should have done. Is that something that interests you and concerns you?
I think it's a really interesting issue. It's still a developing area. I would have said certainly back in 1975 you would have found extreme difficulty in getting a court to decide that such a matter would be justiciable. Generally the view has been taken, well, initially the view was taken that viceregal decisions full stop were not justiciable. That meant that courts could not review them. In more recent times, as administrative law has evolved, decisions of the Governor-General may be reviewed by a court, but when they're administrative sort of decisions that are made pursuant to ministerial advice. The one area that the courts, both in Australia, Canada, United Kingdom, all the Westminster systems, the one area in which the courts have so far said is not justiciable is the area where vice-regal representatives take decisions where they exercise political forms of discretion. So political decisions, so for example, decisions to declare war, those sorts of things are not generally considered justiciable. So highly political decisions and decisions which involve, say for example, an exercise of the reserve powers where a discretion is actually conferred upon the vice-regal representative. So far, no court has ever accepted that those sorts of decisions can be reviewed, and the courts have generally taken the view that those highly political sorts of decisions are not appropriate for review by the courts. Now, we recently saw a bit of a discussion about this in some litigation in the United Kingdom. The case is called the Bancourt case. It was a case about the removal of the the Chagossian people from the British Indian Ocean Territory, BIOT, British Indian Ocean Territory, otherwise known as Diego Garcia, where they put the American base. So when the British rented or leased out Diego Garcia to the Americans, they removed the entire population who were there, sent them off to another island. And since then the Chagossians have been involved in litigation against the British for their entire people being removed from their lands. And so there's been a discussion about the sorts of decisions that courts can review. And in passages in that judgment, most recently in the House of Lords and the lower courts, the courts have discussed the sorts of decisions that might be reviewed by a court and the sorts of decisions that might not. And in the category of might not, they include things like the decision to prorogue Parliament, the decision to dissolve Parliament, the exercise of reserve powers. Those sorts of things, at least in the United Kingdom, are still regarded as not justiciable. So where this article from one of my colleagues in The Australian came from is a new and developing view. It's one that's not yet been recognised by the courts. But what he's been essentially saying is that you might remember the case about implied freedom of political communication, the Australian Capital Television case from 1992, where the High Court said that the Constitution implies a right to freedom of political communication. They did so on the basis of principles of responsible government and representative government that they identified in the Constitution. And so a couple of academics have said, well, taking that approach from the High Court in 1992, perhaps then the court might take other principles of responsible government and constitutionalise them in a way that now, if the Governor or the Governor-General acted in a way that was inconsistent with those principles of responsible government, then perhaps that might be a decision that the court would now regard as justiciable because those conventions and those principles have crystallised into law. Now that's a sort of a creative argument. That's one that's moving from something that was creative in 1992 by the High Court and taking it a step much further. And it's possible that a court might take that sort of approach. But as I say, so far we have no authority supporting that. It's really just speculation as to what a court might do in the future. At the moment, my money is still on the courts just not wanting to get involved in these sorts of decisions, wanting to stay separate from them, respecting the separation of powers between the courts, the executive and the legislature. And something that you often see in court judgments in relation to these sorts of issues is what they call the principle of comity. So that they respect the role of the legislature to do its legislative things, they respect the role of the executive to do its executive things, and the judiciary, although it will adjudicate on the lawfulness of things, otherwise don't want to get involved in those decisions and in those procedures. They don't want to take on the role of being the executive themselves or being the legislature themselves. So for my money, I think that they would try and stay well away from that. However, as I was saying to David beforehand, it's one of those problems where if you get a particularly extreme case in fact, you will often get more creative judgments from the courts. So if, for example, the Governor-General went completely bananas and decided to appoint Bill Shorten or anybody else as Prime Minister, regardless of who led the relevant party, and regardless of their support in the Parliament, in those sort of circumstances, well, yes, maybe a court would take some sort of action because they would be pushed into more creative interpretation of the Constitution. But if a Governor or a Governor-General is behaving within the normal parameters of their office and exercises discretion within those normal parameters, then I doubt very much that it would be justiciable.